Here, the legal warriors, is spitting on somebody a crime in Washington State? We know it'll get you a 1-game suspension in the NFL, asked Jamar Chase. So if you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. We had one of our viewers submit a question through the comments, and anyone feel free to do that. We keep an eye on them, but we do have a lot of comments out there. And the question was something along the lines of, can you get arrested for spitting on someone? Or can you get charged with a crime for spitting on someone? And I think we all might imagine it's pretty easy to think what that answer is. The answer is yes. Yes, spitting on somebody is a crime. The most common crime we would see charged is assault 4th degree. And if it was a family or household member, it could be assault 4th degree domestic violence. Remember, in Washington State, that DV is just a designator that notes the relationship between the suspect and the alleged victim. And if a DV tag gets tacked on, it lets the court do more mean things to the defendant. So what do we care about if we have a spitting case? What are some defenses? What might we want to do about it? And how is it handled differently than other types of assault cases? Well, I think the most common defense that we want to use in some type of spitting case is accident, right? When we talk, some people are wet talkers, right? Some people will get into an argument and something may come out of their mouth. And of course, it's only going to be a crime if we intentionally cause contact by our spitting with the other party. If it's an accident, then that wouldn't be a crime. And I've defended cases before where we could show through enough people that it was an accident, not something else. If you're the one who's suffered this, how would you try to show it's not an accident? Well, we could guess, right? He really, sucked it up before he spit, or there's a lot of spit, or it came in my face. So there's an argument that caused, that type of thing to happen, or witnesses that we would see it. So what's the maximum penalty should we have just a regular old spitting case? The maximum penalty in Washington State for an assault charge, assault in 4th degree, a non-felony, would be 364 days in jail and a $5,000 fine. So how are those type of cases handled by the prosecutor? Well, I mentioned the NFL in the start of this. In the National Football League, that's one of the most offensive things that someone can do to someone on the field. That's why now there seems to be a 1-game suspension, just like a receiver Chase from the Bengals just got here within this. I think he missed this last week's game from spitting. Why doesn't he get charged with the crime in the NFL? Well, because some level of contact is sort of consented to as part of the NFL. In sporting events, there have been people charged with crimes like hockey players, like smashing someone over the head when they didn't have on a helmet, and that were wasn't consented to. But for the NFL, it's really offensive, and oftentimes it is for prosecutors as well, right? It's one of sort of the most disrespectful ways that you can get at somebody. And also, depending on where the spit happens, is it in someone's eye where it can infect them with something else? Is it just on their shirt? Does it go on their leg? And so oftentimes the prosecutors will take a pretty aggressive stance to begin with in that type of case. So how would we defend that if the prosecutor's taking an aggressive stance? Let's say we don't have a great claim for accident. Then what do? Well, then we start looking at mitigation, right? Mitigation. We're big about classes when it comes to mitigation because we want to make the prosecutors see the light. Perhaps we have our client do an anger management class. Perhaps some type of counseling. Perhaps we don't make an excuse, but we make an explanation of why it is that we weren't the initial aggressor, and we didn't beat someone up. We didn't cause physical injury. The reason why we did this was a reason about how we were aggressed against first, and also there can be things like apology letters, stuff like that. That would have first go to your attorney because we don't want to give admissions. But there's lots of times that if we use time and let time pass and then tell the whole story of who the suspect is, not this one isolated incident when someone was in conflict, that cooler heads will prevail over time. Remember, typically a 3-step process to being successful with low risk for the client in non-felony cases. One is some purposeful delay. We want people to cool down and not be so angry. 2 is some type of affirmative actions on behalf of the suspect or the client, right? It's not the prosecutor's job to let us go. It's the prosecutor's job to respond to the case. If we do nothing affirmative, well, then they only have one response: conviction and jail. And then step 3 is, how is it that we talk to the prosecutor? What do we know about them? What do we know about their caseload and what's important to them and what's normal in the court? Those are steps that we take to try to get us out of, in this case, a literal mess. What can complicate things? Hopefully there's no other types of slurs going on. Usually there's a lot of disdain that happens if it's a true spitting case, and let's hope it's not spitting on police officers, because then we're not talking about a gross misdemeanor, we're talking about a felony charge. We spit on a police officer, that's assault in the 3rd degree, which is a felony. If we spit on a nurse or a doctor or an EMT or someone while they're doing their duties, the helping first responder type of jobs have a special carve out, and if we assault them, including by spitting, while they're doing their duties, then we go from a gross misdemeanor to a felony where we're looking at 5 years in prison, stuff like that, maximum. Although that's going to the type of sentence we get is going to depend on our offender score and how many prior charges we have. Can we argue self-defense in a spitting case? I could see a way you could. Someone's coming at you, about to hit you, and to stop them, you shock them by spitting in their face or something. I could see that argued. I've seen that type of craziness actually argued in protection order hearings. I don't even want to talk about what I've seen in the protection order world, the civil world, when it comes to what commissioners think is or isn't self-defense. But I've yet to see that in a criminal case where that would actually work. But theoretically, on a law school exam, it might. So hope that answers your question out there, viewer. Thank you for watching this, and I hope anyone else has got some benefit out of this. Feel free to comment about what you think about this in the comments. Should it be a crime? Shouldn't it be a crime? I think in Texas, they would just shake our hand, right? Maybe not. So anyway, if you found it useful, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you got a criminal matter in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.